It is getting deleted repeatedly, my lord.
No, you have to circulate the letter now. No further.
As an item 8, I have circulated a letter to file editing.
So when it's called on,
Before my lord.
Yesterday's matter 61.
61, yes, continuing.
Item 61.
Now, Mr. Salve,
Yes.
it's a pleasure to hear you, but all your colleagues are waiting. How long would you take?
Lord,
Have a brief idea so that we can arrange our.
I've got the note ready.
Okay.
What I need to do is, there are some judgments which have been relied on since the Lordship are
So
hearing the matter.
can we say about 1 hour or?
About an hour. I'll finish. I'm finish in 1 hour.
So I'll come at 1 hour. I've been waiting for my turn for the last 3 days.
Your choice.
And for a matter where the issue is only whether notice should be issued or not.
And I think we are past that stage.
I'm sorry, we haven't passed that stage. The stage is that the court said they will hear me.
Raising his voice won't help us. So your Lordship to decide.
I'm not raising my voice. I'm saying it was made clear that the Lordship, yes, and the Lordship will decide whether notice is issued or not. That is how it started, and that's how I want
Friend
to.
appears for a caveat, and he's worried about whether notice will go.
I'm not worried. I'm saying it should not go.
Okay.
This is a gross case. But I will address your Lordship in my turn.
File caveat.
Yes, on behalf of the state, there are 2 respondents.
Under which provision?
There is a provision for file.
Just wanted, because I personally checked the Supreme Court rules and I didn't find any in criminal. SLP criminal, can you file caveat?
So there are orders, but I can show them. I'll bring it in this.
It's all technical, but just
I follow that.
for my
If necessary,
for clarity.
I'll show. I appear for one respondent.
Permit you to argue, no doubt about
Dreadful,
it.
but I will also look at it. Your Lordship has mentioned it.
We him notice probably if we allow you to argue.
Lord, I mean, that's a.
See.
I must say this. If surely after hearing this matter for so long, if your Lordship feels it doesn't call for a notice, I'll sit down right now. But if your Lordship feels it calls for consideration, I mean, if my friend is going to ask for an adjournment, then we might as well get nothing.
Will let us not preempt the courts of.
I am not asking for any adjournment. I am saying it should be dismissed. That's what I will not endeavor to tell the court.
That's fine. But it can't be at the end of it, then you say, all right, then I'll file a reply. But then
No, counter affidavit is already filed.
not
No, it's not fine.
Oh.
If there is no notice, how will there be a counter?
No, but what was that was before the.
That's before the High Court.
I only not want to say, Lordship has not asked me a question. I'm only saying, if at the end of 1 more hour, my friend is going to say, Lordships have heard me fully, and a Lordship feels requires consideration, then will he ask for an adjournment or will he go on? That's something a Lordship will have to consider.
Will.
I don't want to answer that. See what will happen.
These kind of things one shouldn't, I think they are far too serious rather than what is.
Was not originally conceived under Article 136. That is possible.
Neither will not is the
Not
civil
notice for
procedure code.
interim relief.
No, it has evolved through practice.
Correct.
Lord, neither in the civil procedure code is there a provision for notice. It has been evolved, Lord, in the last 30, 40 years.
Has been
It has happened.
from evolution now reached
It has become a law.
So you first hear a matter 3 days whether your Lordship will issue notice, then you hear it for 6 days after you issue notice to grant you,
What?
and then the appeal will ask for 2 hours.
You can correct us if wrong. Initially, it was either granting leave or
Of course,
dismiss.
of course.
I think that's
With
how.
respect, yes, my lord. And then this notice process came because if an interim order is sought, only fair you hear the other side. Otherwise, I remember, in fact, back in the day, the rule, your Lordship, and that's why I introduced the rule, saying if there a counter in the High Court, please file it before us. So we want to know what the other side's case is, and then we decide. So ultimately, what is it? Your
So the
Lordship,
entire record is with us. So
entire record is here.
no need to as such.
Exactly. And in a criminal case, where is the counter affidavit?
Lord, that's now the procedure of this court, that a Lordship grant, if we go back to the old days, then follow the full practice. That a Lordship grant an ad interim order, grant leave. There is no need to hear the other side even for ad interim.
Normally, we take into consideration only those documents which were already produced before the High Court.
Agreed. Things have changed over the years. people give documents across, all this is happening. So if you have a restatement of the law, then we should go back to that position. Where there is no counter affidavit,
Continue.
record of the court, all that is there.
May I, my lord,
Everything is-
start?
Yeah.
Start to finish 60 minutes. I have, my lord, for your lordship's assistance, put my thoughts down in a piece of. Thanks. It's become 5 pages.
Just spacing.
And it looks big because the font is large and the spacing is large.
No, that's okay. That's
It's a relief on the eye.
good for us.
I've covered most of this ground. my lord. Section 17A inserted relates to the procedure by which an inquiry, or investigation into an offence is conducted. It is a procedural provision which does not carry the obligation or impair any rights of a citizen. Provision would thus be retroactive in the sense it would apply in future in relation to all inquiries or investigations being conducted. Such provisions have loosely been characterized as retrospective. Strictly speaking, provisions that operate in the future but antecedent facts are in that sense not retrospective. In fact, my lord, this is well settled. If you rely on, if a situation is on antecedent facts, the famous three-judge bench decision in DCM relied on the English principle of construction, where for the first time company deposit rules were brought in. And the argument was this can't be retrospective, it can only apply to deposits received hereafter. Justice D. Desai, my lord, in this court took the view that no, it will apply to deposits hereafter, not to deposits received hereafter. So it is not retrospective. Merely because a law for its prospective operation relies on antecedent facts doesn't make it retrospective.
They all come from that colonial sugar.
Colonial sugar. Because the principle, as your lordships know, is this: it is not that an FIR already registered prior to 18 is invalidated. That would be retrospective. But if after today you commence or initiate any inquiry or investigation, this section will apply. So it is not retrospective. It is prospective.
By necessary corollary, probably a next question which would arise according to me. If you said that this is a procedural and
Surely.
would it confer any substantive right on the accused?
The right,
If not followed.
yes, the right, that's a very important point.
Then that Garikapati
Yes.
principle.
This court has held sanction provisions, although procedural in nature, are a protection available to the accused and have to be rigorously followed.
In which judgment?
Yes, I'll give those cases. In fact, in Tata, your lordships have allowed appeal saying sanction will not
Well,
be.
if you see in the context of section 19 and 19 4C.
Yes, your lordships have invalidated it.
Yes, invalid.
Set aside convictions.
Yes.
Not the, in Tada, for example, a serious thing like Tada, one of my lord's judges, the lordship has set aside the conviction. Then, and I was wanting to show, I'll be showing that judgment also because it deals with the other aspect. What if there are other offences which are not covered by a provision which requires sanction? Then
See.
what your lordships have held is, what
Yes.
your lordships have held is that if the other allegations are ancillary in character, then everything goes. And if the allegations are substantive in character, then they may remain, but the Tata go. So approval, sanction has always been considered, absence of prior sanction has always been considered fatal to the inquiry. And all that is required is you go now, you get the governor's sanction, you register the FIR. It's not that, my lord, the accused gets a discharge or is acquitted or author for acquittal apply, nothing of the sort. It's a safeguard. You haven't crossed this. Up till now, whatever you've done is illegal. You go get the sanction and you register the FIR, and you're back on track. It's not that the offences are eviscerated. So substantive right, not in the sense that you get go, as they say, get out of jail free pass. That's not what happens. Only this inquiry comes to an end. About para 5 is conducted prior to insertion of the provision, not stand invalidity. That would make it retrospective. In that sense, the provision retrospective. However, all inquiries, it should be in that sense. The provision is not retrospective. I'm sorry, there's a typo there. maybe please, I'm so sorry, please add, provision is not retrospective. However, all inquiries or investigations commenced by a police officer after the insertion of 17A would be governed by the provision. The general principle of the said provision being retroactive can be displaced by express language. So, but these are only general rules of interpretation. Parliament could have limited the application of the provision to inquiries or investigations commenced in relation to offences committed after the insertion of the provision by adding the words hereafter after the words into any offence alleged to have been committed by a public servant. I made this point yesterday, just for convenience. I put all of them down in writing. The legislature was consciously made a provision applicable to a person who is or was employed. The investigation into past offences is clearly visualized by the Act. Words of limitation as set out are conspicuous by their absence. 17AC provides that no inquiry or investigation shall be committed into an offence alleged to have been committed by a public servant without the previous approval, in the case of any other person, of the authority competent to remove him from his office at the time when this was alleged to have been committed. This is intrinsic evidence to suggest that the provision was intended to apply to offences committed in the past without any limitation. The second feature of this provision is that it applies to an inquiry or investigation into an offence alleged to have been committed by a public servant. The focus of the provision is thus affirmed. The person who has it extends to one. I'm sorry, that word is a typo. The focus of this provision thus extends to the person who has committed the offence and not merely the offence. I had made this point yesterday also. It applies wherever the offence relates to any recommendation made or decision taken by such public servant in the discharge of his official function. Private acts of a person not in the capacity of a public servant acting in discharge of his official duties are not protected by this provision. The phrase any recommendation made or decision taken in discharge of his official function or duties was inserted to limit the need for prior approval to official acts of public persons and not acts in their private capacity. Suggestions referring undue or otherwise indulging in acts which constitute an offence under the Act are not acts in discharge of official duty misconceived. Such an interpretation would render the provisions issues. But if you say, that's what the High Court said, oh, but abusing your power is not official duty, but then this Act applies if you abuse your power. So, to say that if you committed an offence under this Act, it is not in discharge of official duty, so then, then very 17A. The interpretation of this provision in the concurring judgment of Mr. Justice Joseph in Yashwant Sina, it is respectfully submitted, lays down the law authoritatively. Statement of objections. Statement of objects. Oh my God. I'm so sorry, Manat. It's full of typos. Statement of raised supports the interpretation provision designed to protect public servants from motivated prosecution.
Did you take help of Dragon? Or?
No, Manat. I didn't read the steno. For a change, I used a stenographer because I didn't have my Dragon laptop. Otherwise, that's very accurate. Or otherwise, I do all my own dictation and typing.
Dragon also checks the spelling and grammar also.
Yes, it does. Then, Manat, the standard operating provision, procedure I have shown your lordship. Then jurisdictional act, etc. They are all judgments which are all here, Manat. So only to put it all in one. And in para 17, I have said, Manat, the two areas the High Court judgment suffers from.